So good morning, friends. So in the previous class, we had a discussion on restrictions on fundamental rights, alright, and we concluded that state has every power. State has every power state has the power to impose reasonable restrictions. State has every power to impose reasonable restrictions. Alright. So this is what we have said. And the test of reasonability, is given in A.K. Gopalan case. Alright. So just I am rewinding the previous class because it is already a 2 days gap. That is, the last class was on Friday. So after Friday we had almost all 3 days gap. Right. So my guess is that you might have forgot all this what you call previous class. So because of this, I want to give a brief revision of what we have discussed in the previous class. Alright. So it was in A.K. Gopalan case where for the first time Supreme Court has talked about the test of reasonability. Right. So it was in Supreme A.K. Gopalan versus State of Madras case. A.K. Gopalan versus State of Madras case. So it was in this case. For the first time Supreme Court upheld the power of state to impose restrictions and said that every restriction should be reasonable in nature. And apart from this, Supreme Court also held that right, the restrictions will be called as reasonable if the executive follows the procedure established by law. Alright, the restrictions will be called as reasonable if the executive, that means the government follows the procedure established by law. That means Supreme Court in A.K. Gopalan case highlighted the doctrine of procedure established by law. Alright. So which was mentioned in Article 21. So every restriction that is imposed by state should be according to this procedure established by law. Alright. So government should follow the law that is given and government should follow the procedure as given in the law. So this was said by Supreme Court in A.K. Gopalan case. So this is the first case where Supreme Court upheld the power of government to impose restrictions. Another important of this case is, it was in this case, alright, the concept of judicial review. The concept of judicial review was highlighted by Supreme Court. So it is Supreme Court that will test, the reasonability of restrictions. That means, alright, the judiciary led by Supreme Court. So Supreme Court has every power to examine the restrictions imposed by the state, and it is Supreme Court that will check whether the restrictions imposed are reasonable or not. Alright, that means Supreme Court has every power to examine. So we call this as judicial review. So the concept of judicial review was first highlighted by Supreme Court in A.K. Gopalan versus State of Madras case. So it was in this A.K. Gopalan case. right? So this is what we have discussed, and this what we call reasonability, it is called as procedural reasonability, right? So it is termed as procedural reasonability. It is procedural reasonability. That means Supreme Court has highlighted this procedural reasonableness in A.K. Gopalan case. Alright. So this is one part of reasonability. Second part of reasonability is, alright, the restrictions will be called as reasonable not only following the procedure given by law, but they will be called as reasonable if the law that is used to impose restrictions is just and fair. Alright. So restrictions will be called as reasonable. Restrictions will be called as reasonable, alright, if the law that is used is just and fair. So this was highlighted by Supreme Court in Menaka Gandhi case. Menaka Gandhi versus Union of India case. So it was in this case, Supreme Court said that every law that is used should be just and fair. Alright. So this is given by Supreme Court by using the doctrine of due process of law. Alright. A doctrine that is taken from American Constitution. That means, alright, the law that is used should be just and fair. Alright. It should not be unfair or unjust laws. So not only following the procedure given by law, but also the law that is used should be just and fair. So this is what said by Supreme Court in Menaka Gandhi case. That means Supreme Court has widened the definition of reasonability. Supreme Court has widened the definition of reasonability in Menaka Gandhi case. Whereas if you take A.K. Gopalan case, in A.K. Gopalan case, Supreme Court had a narrow interpretation. Right? In A.K. Gopalan case, Supreme Court had a narrow interpretation of what you call, alright, reasonability of restrictions. So here a narrow view is taken, whereas in A.K. Gopalan case, right, Supreme Court has widened the definition of, what you call reasonability of restrictions, right, and said that every restriction imposed on the rights of individuals should be according to law, and the law that is used should be just and fair laws. Right. So this is what about Supreme Court's interpretation. On what you call reasonability of restrictions. Right. So this is what we have discussed in the previous class. Right. So previously this is what we have discussed. Okay. Now whether I gave a question on this part, whether in the previous class I have given a question on restrictions on fundamental rights. Okay. So now going to the next debate, it is debate on amendability of fundamental rights. Right. So this is another interesting debate that took place in India in the initial years of commencement of Constitution. There was another debate that took place, right? Because the reason for this debate is, one is amending Article 31. The reason for this debate is it is amending Article 31 and other article is it is Article 15. Alright. So as we know, again even today in the recent past, that is in the last 1 month, there is much discussion on this right to property because the Supreme Court has constituted a 9-judge bench on the issue of redistribution of wealth, whether state has the power, whether state can acquire the wealth of individual in the name of redistribution. So the present Supreme Court has constituted a 9-judge bench on this issue of right to property. That means, I think if you ask me, right to property is an unending debate in India, right? So right from 1951 till date, we are having this debate, all right? And another interesting debate that is on reservations, right? So we have two sides of the arguments, right? Some people say that, no one says that reservations are unwanted, but there is a debate that reservations are being misused in India, all right? The topic of reservations. So why we require reservations? Why we require reservations? Because today every section of Indian society is demanding reservations, all right? So in the recent past, the government of India has enacted what you call the 103rd Amendment Act, that is providing of reservations for the economically weaker sections in the general category. Alright. So these are the debates. So which started from 1951, that is right from the date of commencement of Constitution. Right from the date of commencement of Constitution, we had these debates in India. Alright. So debate on Article 31, debate on Article 15. Alright. Right to property as well as reservations. Right. So here I will just try to give the backdrop of this debate. Alright, by very first Amendment Act, the Government of India has added 9th schedule. Alright, the Government of India has added 9th schedule. Alright, so it is added by First Amendment Act. It is added by First Amendment Act. Alright, so now, the purpose of this what you call 9th schedule, right? The purpose of this 9th schedule is to provide immunity, that is protection. The purpose of this 9th schedule is to provide immunity, right? Immunity or protection. So from whom this immunity is required? From whom this protection is required, right? So immunity or protection is given to the laws. Immunity or protection is given to the laws from whom? From Supreme Court or from judiciary. Protection is given from questioning by Supreme Court or judiciary, right? Simply to say, Supreme Court is not allowed to question. Supreme Court is not allowed to question the laws which are inserted in 9th schedule. That is, all those laws which are inserted in 9th schedule, they are outside the scope of Supreme Court. That means the Supreme Court has no power to question these laws, right? So protection is from Supreme Court. So protection is for laws inserted in 9th schedule, right? So what kind of laws are present in this 9th schedule? What kind of laws are present in 9th schedule? So remember, 9th schedule contained the laws dealing with, right? One is implementation of what you call government laws on right to property. It contained laws on right to property. It contained laws on reservations, right? So one is laws on land reforms. It contained land reforms. Second one is, right, it contained laws on reservations. Right. So these are the laws which are mentioned in 9th schedule. So 9th schedule contained laws on land reforms and laws on reservations. Because if you take these land reforms, the purpose of land reforms is to redistribute the excess what you call land among the landless poor people. It is a single line. The ultimate aim of land reforms, is to redistribute the excess land among the landless poor people. So land is a property of the individual. So to take this excess land, right, there is a need to restrict, there is a need to amend right to property, there is a need to amend Article 31. That is the reason why government went on amending Article 31. Government went on restricting right to property, and all these laws are inserted in 9th schedule. So, and as said by the amendment, right, as said by amendment, these laws cannot be questioned by Supreme Court. They cannot be questioned in court of law, including Supreme Court. Right? Say for example, right, the Jawaharlal Nehru government has amended Article 31, inserting Article 31A as well as Article 31B. Similarly, right, Indira Gandhi government has again amended Article 31, inserting Article 31C and Article 31D. Simply to say, Bab has added 31A and 31B, Beti has added what you call 31C and 31D. Ante both Bap and Beti has played with the constitution. Alright. So this is what about 9th schedule. Alright. Now, when this 9th schedule, when land reform laws, when reservation laws were challenged in Supreme Court, so what Supreme Court has said? Let us examine the the stand of Supreme Court, the opinion of Supreme Court. Alright. In the previous classes, I have mentioned about two cases. One is Shankari Prasad versus Union of India case. Second one is Sajjan Singh versus what you call State of Rajasthan case. Alright. Once again, I will bring these cases. If you take stand of Supreme Court, what Supreme Court said, what Supreme Court has said. Alright. So, Shankari Prasad versus State of Rajasthan case. I'm sorry, Shankari Prasad versus Union of India case. Union of India. Second one, Champakam Durai Rajan. Champakam Durarajan versus State of Madras case. Champakam Durarajan versus State of Madras case. Alright. Sajjan Singh versus State of Rajasthan. Alright. So, if you take Shankari Prasad case and Sajjan Singh case, right? It is about Article 31. Right? They have, right? It is land reform laws that were challenged in Supreme Court. That is both in Shankari Prasad case as well as in Sajjan Singh case. It is land reform laws. It is land reform laws. Whereas Champakam Durai Rajan versus State of Madras case, it is reservation laws. Alright. So all these issues, right? All these issues. In these cases, Supreme Court has upheld the power of Parliament to amend fundamental rights. Alright. So Supreme Court has supported power of Parliament. Supreme Court has supported power of Parliament to amend fundamental rights. Alright. So Supreme Court clearly said that Parliament has every power to amend fundamental rights. It has the power to amend constitution, including power to amend fundamental rights, right? So initially, right, the judgment, the Supreme Court stand, the Supreme Court stand was in favor of Parliament. The Supreme Court stand was in favor of Parliament. That means Supreme Court has supported the power of Parliament to amend the Constitution, power of Parliament to amend fundamental rights, right? Fundamental rights in particular, and Constitution in general. That is, Parliament was given the power. So Parliament has the power to amend fundamental rights. Alright. So the changes made to Article 31 as well as the changes made to Article 15 were supported. Alright. And even if you take this judgment on 9th schedule, Supreme Court clearly said that Parliament has every power to amend the Constitution, and it has supported what you call the insertion of 9th schedule into the Indian Constitution. Originally in our Constitution we had only 8 schedules. Right? But from 1951 onward, that is right from First Amendment Act, we see addition of different schedules. Right? The first schedule that was added is 9th schedule. So Supreme Court upheld this 9th schedule. Upheld means supporting. Right? Upheld means supporting. So Supreme Court supported 9th schedule. Supreme Court has supported the subject matter of 9th schedule. Right? So as Parliament clearly said that judiciary has no role. Right? What by First Amendment Act, what Parliament said. Right? All those laws made by Parliament and inserted in 9th schedule, they cannot be questioned in Supreme Court. Right? And we have a clear principle that Supreme Court should not interfere with the work of Parliament, and Parliament should not interfere with the work of judiciary. Right? So there is a mutual bar between, that is, both are mutually restricted to interfere in each other. So Supreme Court should not interfere in the work of Parliament, and the Parliament should not interfere with the work of legislature. Alright? So this is what the Supreme Court clearly upheld in what we call Shankar Prasad case as well as in other cases. Alright? That means Supreme Court clearly restricted itself in entertaining the laws amending the fundamental rights. That means, simply to say, Supreme Court said that, right, the laws which are inserted in 9th schedule, they cannot be questioned in Supreme Court. That means what? Supreme Court has simply supported the stand of government. Right? Supreme Court has simply supported the stand of government. Right? Alright. So this is what the stand, and this is what you call initial views. That means initially, right, Supreme Court justified the power of Parliament to amend fundamental rights. But there was a complete U-turn took place in Golaknath versus State of Punjab case. Golaknath versus State of Punjab case. In Golaknath versus State of Punjab case, Supreme Court took a U-turn. The 11-judge bench of Supreme Court, right? The 11-judge bench of Supreme Court, alright, said that, the 11-judge bench of Supreme Court said that Parliament has no power to amend the Constitution. In Golaknath case, Supreme Court said that Parliament has no power to amend the Constitution, no power to amend fundamental rights and Constitution. That means simply Supreme Court put a brake on the power of Parliament. Right? Supreme Court put a brake on the power of Parliament by saying that Parliament has no power to amend the Constitution. It said that right? It has imposed the brakes, right? Then, if not Parliament, a new kind of interpretation was brought by Supreme Court in Golaknath case, a very interesting case, right? Entirely a new kind of interpretation, right? So, if not Parliament, then who has the power? If not Parliament, then who has the power to impose restrictions on fundamental rights? Then, for this question, Supreme Court said that, right, a new constituent assembly should be created. A new constituent assembly should be created to amend the constitution, because who drafted Indian constitution? Who has drafted Indian constitution? Alright, the Indian constitution was drafted by constituent assembly. That means what? To amend the constitution, to change the constitution, who has the power to change this? Again, it is again constituent assembly, that is Supreme Court in this. See, remember, it is not my view, it is the Supreme Court view in Golaknath case. So, in this case, Supreme Court said that, right, it is a new constituent assembly, right, that should be created to amend fundamental rights. And it said that fundamental rights are given a sacrosanct position, right? They enjoy a sacrosanct position in Indian constitution. So, what do you mean by sacrosanct position? Sacrosanct means the superior, right? It is given an important place in Indian constitution when compared to other parts of constitution. When compared to other parts like part 3 is given, right, part 3 is given a sacrosanct position, right? So, because of this, right, Parliament has no power to amend fundamental rights. And in fact, alright, there was a question on constituent powers of Parliament. So, Supreme Court in this case said that Parliament has no constituent powers, right? No constituent powers are given to Parliament. No constituent powers are given to Parliament. No constituent powers are given to Parliament. So, first of all, you should know the meaning of constituent powers. What do you mean by constituent powers? Alright, constituent power means the power to rewrite the constitution. Alright, remember, constituent powers. Constituent powers means the power to rewrite the constitution. Right, constituent powers means it is the power to rewrite the constitution. Right, that is what meant by constituent powers. Right. So, Supreme Court in Golaknath case, said that, held that Parliament has no power to rewrite the constitution. It cannot rewrite the constitution. Okay. So, this is what said by Supreme Court. Right. That means you cannot compare Indian Parliament. You cannot compare Indian Parliament with the British Parliament. British Parliament enjoys constituent powers. Whereas Indian Constitution doesn't enjoy constituent powers. So, you cannot compare Indian Constitution with that of British Constitution. Indian Parliament with that of British Parliament. Right? So, British Parliament enjoys constituent powers, where Indian Constitution doesn't enjoy any constituent powers. Alright. So, this is what held by Supreme Court. That means, right, the Parliament has no power. The Parliament has no power to amend the Constitution, right, amend fundamental rights. Right. It cannot claim, the Parliament cannot claim any constituent powers. Right. So, this was entirely a new judgment that was given by Supreme Court in Indian history. That is the reason why, right, in Golaknath case is regarded as one of the landmark case in Indian judicial history. Right, Golaknath case is one of the landmark judgment, and it was in this case Supreme Court said that preamble is eternal part, preamble is soul of constitution, which you cannot change, which you cannot amend. That is, right, amendments cannot be, amending procedure or amending procedure cannot be what you call enacted on preamble. So no part of Indian constitution can be amended. Parliament has no power to amend Indian constitution. Alright. So this is clearly held. This is clearly held by Supreme Court. Alright. An entirely new judgment. So the impact of this judgment is that if you take this impact of judgment, alright, because of this judgment, Parliament was not allowed to amend constitution, it was not allowed to amend fundamental rights, right. Simply brakes were imposed, brakes were applied on the amending powers of Parliament, right. Brakes were applied on amending powers of Parliament. Brakes were applied on amending powers of Parliament. That means what? The Parliament is not allowed. Parliament is not allowed to amend fundamental rights. Parliament is not allowed to amend Constitution. Alright. So this is what Supreme Court said. Alright. Now don't just think it as entirely a new judgment. Yes or no? So definitely it is, right, a new judgment. Alright. That means simply what? Parliament is restricted, right? Because of this judgment, Parliament is restricted. Alright. I am clear on this point. Till now I am clear. So we have discussed, right, the what you call the power of Parliament before this Golaknath case and the power of Parliament after this Golaknath case. So that is the reason why when we read what you call power of Parliament to amend the Constitution, we always take Golaknath case as a landmark and say that before Golaknath case and after Golaknath case. So before Golaknath case, the position was that Parliament has every power to amend the Constitution, and after Golaknath case, Parliament lost its power. Parliament has lost its power to amend the Constitution. Alright. So this is what the issue, right, till Golaknath case. Now in 1971, when Indira Gandhi came to power, came to power, she has brought what you call two important amendments, that is 24th Amendment Act as well as 25th Amendment Act. Right. So these 24th Amendment Act and 25th Amendment Act has been made by Indira Gandhi government, violating the Supreme Court judgment given in Golaknath case. Right. 24th Amendment Act and 25th Amendment Act. 24th Amendment Act and 25th Amendment Act. Alright. So these were made in 1971. Both these amendments, both 24th Amendment Act and 25th Amendment Act, they were made in 1971. Alright. 1971. The specialty of these amendments is they were made, right, by violating, these two amendments are violated, right, the judgment given by Supreme Court in Golaknath case. Alright. What Supreme Court said in Golaknath case? Supreme Court said that Parliament has no power to amend Constitution, Parliament has no power to amend fundamental rights. Exactly opposite was done by this 24th and 25th Amendment Act, right. So by this 24th and 25th Amendment Acts, exactly opposite is done to the Supreme Court judgments, right. So I'll give a simple, so in this class just try to know what was done by 24th Amendment Act, right. So by 24th Amendment Act, by this 24th Amendment Act, right? The Parliament has amended Article 13 as well as Article 368. Article 13 and Article 368. Alright, that means what? Simply by amending Article 13, by amending Article 13, alright, Supreme Court was not allowed to question the laws made by Parliament, including constitutional amendment laws, right? So by amending Article 13, right, Supreme Court was not allowed to question. Supreme Court was not allowed to question, all right, the laws made by Parliament. Whatever law, may it be the constitutional amendment law. That means any law that is made by Parliament, including constitutional amendment laws, they are, right, they cannot be questioned in court of law, including Supreme Court. So that means the laws made by Parliament, including constitutional amendment laws, they cannot be questioned in Supreme Court. So this is what said by 24th Amendment Act. So by amending Article 13, Supreme Court, the Parliament said that, right, the laws made by Parliament cannot be questioned in Supreme Court. Cannot be questioned in Supreme Court. And by amending Article 368, President was made bound to give his assent on constitutional amendment laws. Right? Simply to say, all the right, President is bound to give his assent. President is bound to give assent President is bound to give his assent on constitutional amendment laws. That means what? President has no veto powers. That means President cannot reject a constitutional amendment law made by Parliament. So President has no power. President has no power to reject. A constitutional amendment law. He has no power to reject a constitutional amendment law that is made by Parliament, and he should give his signature. President should give his signature. There is no other option for President. So whenever a constitutional amendment law is made, by President, right? Whenever a constitutional amendment law is made by Parliament, President has to give his signature. So that is the compulsion imposed on President by 24th Amendment Act, right? So by amending Article 13, Supreme Court was not allowed to question the laws made by Parliament. By amending Article 368, President was made compulsory, right? President was made compulsory to give his signature. Remember what Indira Gandhi government has done. Indira Gandhi government has took away the judicial safeguard, right, by dissolving Supreme Court. At the same time, right, Indira Gandhi government also took away the safeguards from President, right? So even President cannot question. The constitutional amendment laws which are made by Parliament, they cannot be questioned neither by Supreme Court nor by President, because without President's signature, no law will be enacted. But what is done here? What was done to President? So President was made compulsory, right? So President was totally tied up. He was made compulsory to give his signature. He is bound to give his assent. He shall give his assent. He should give his assent. That means both these safeguards were taken away, right? So by 24th Amendment Act, all right, these safeguards were taken away. All right. right? That is Supreme Court. Supreme Court lost its power, including President of India. Alright, so this is the significance of this 24th Amendment Act. So that is the reason why 24th Amendment Act has become the controversial Amendment Act in India. Right? So we know about Indira Gandhi. Every law made by Indira Gandhi has become more controversial. Right? Because the reason is she has altered the balance of powers. She took away the powers of Supreme Court. She took away the powers of President. Right? Supreme Court was made helpless. President was made helpless. Parliament was made helpless. Right? She, what do you call it? Indira Gandhi has become a monarch. That is the reason why Indira Gandhi is known for her bold decisions. Right? Indira Gandhi was very strong in the decisions. Right? And she is called as Iron Lady of India. Right? She is called as Iron Lady of India. Alright? Who is Iron Lady of the world? So give your answer in the comment box. Alright? Who is called as Iron Lady of the world? So we call Indira Gandhi as Iron Lady of India. Alright? Then who is Iron Lady of the world? Alright? So So this is about 24th Amendment Act. Right? This is about 24th Amendment Act, and by 25th Amendment Act, right, Indira Gandhi government has amended Article 31, by inserting Article 31C and Article 31D. Right? So Article 31C and Article 31D were inserted by 25th Amendment Act. That means she has amended fundamental rights. And according to 24th Amendment Act, can they be questioned in Supreme Court? No. She is very wise. Right? So by the 25th Amendment Act, she has amended Article 31, and according to 24th Amendment Act, the laws cannot be questioned in Supreme Court. And President has to give his signature. Alright? So this is what 24th and 25th Amendment Acts, which were passed in 1971. Right? So both these acts were passed. Both these acts were passed in 1971. Alright? So now both 24th Amendment Act, 25th Amendment Act, they have become more controversial in nature. Right? And what Government of India has done? Again, Government of India has started what you call restricting right to property. Right? The right to property of individuals. The right to property of individuals again been restricted. So once again, this issue has come to Supreme Court in the form of Keshavananda Bharati versus right state of Kerala case. Right? The entire issue has come in the form of Keshavananda Bharati versus state of Kerala case. So this is another landmark judgment in India. Right? Keshavananda Bharati versus state of Kerala case. So here important issues that were questioned, that were debated are: one is the judgment of Supreme Court in Golaknath case. Judgment of Golaknath case. Judgment of Golaknath case. Second one is validity of 24th and 25th Amendment Acts. Validity of 24th and 25th Amendment Acts. Right? So these are though there are other issues, but these are the important issues, right, which came for debate in Keshavananda Bharati case. That is power of Parliament to amend the Constitution. Power of Parliament to amend the constitution. So these are the important issues. These are the important issues which came for discussion. Now, coming on to the first issue, all right, the 13 judge bench of Supreme Court. So it is the 13 judge bench. It is 13 judge bench that has discussed Keshavananda Bharati case. It is 13 judge bench that has discussed Keshavananda Bharati case. So in this case, Supreme Court, Supreme Court held that, right? Supreme Court disapproved the judgment given by Supreme Court in Golaknath case. That is, the Golaknath case judgment has been rejected by Supreme Court in Keshavananda Bharati case. Alright, that means what? Supreme Court in Keshavananda Bharati case clearly said that, alright, Parliament has every power to amend the constitution. Alright, Parliament has every power to amend the constitution. Okay, it can amend constitution, right? So it can amend any part of constitution. It can amend any part of constitution. Alright, so Supreme Court clearly interpreted Article 368. Supreme Court clearly interpreted Article 368, saying that Article 368 provides both the power of Parliament to amend the constitution, power of Parliament to amend the constitution. At the same time, it also deals with the procedure. It also deals with procedure for amending the constitution. Power of Parliament to amend the constitution as well as procedure for amending the constitution. Alright. So these were clearly upheld. Right. So if you take the Golaknath case judgment, what Supreme Court said in Golaknath case? It said that Parliament has no power to amend the constitution. Alright. And to amend the constitution, it said that a new constituent assembly should be created. But in Keshavananda Bharati case, Supreme Court said that Parliament alone has the power to amend constitution. Parliament is the sole institution. So this is the exact wordings, right? Parliament is the sole institution to amend constitution. So no constituent assembly should be created. No constituent assembly need to be created for amending the constitution. All right. No need to have a new constituent assembly. No need to have a new constituent assembly. All right. So it is just Parliament. So Parliament alone has the power to amend constitution. All right, amend constitution. But though Parliament has the power to amend constitution, Supreme Court said that though Parliament has the power to amend constitution, all right, it cannot amend the basic structure of constitution. So Supreme Court has brought a new doctrine. The importance of this, the highlight of this case in the Bharati case is, it is in this case, Supreme Court has brought a new doctrine called as doctrine of basic structure of constitution. Right, doctrine of basic structure or doctrine of basic features of constitution. So though Parliament has the power to amend constitution, but Parliament cannot amend the basic structure or the basic features of Indian constitution. It cannot amend basic features of Indian constitution. So that means there are two things. On one hand, the Parliament says that it has the power to amend constitution. On the other hand, it says that it cannot amend basic structure. And Article 13 as well as Article 368 they were treated as basic structure of constitution. Supreme Court in Keshavananda Bharati case, Supreme Court in Keshavananda Bharati case held that Article 13 and Article 368 are basic structures of Indian constitution. That means if they are basic structures of constitution, can they be amended? No. Then what about validity of our 24th Amendment Act? Whether they are valid or invalid? Yet according to this Supreme Court judgment in Keshavananda Bharati case, the 24th Amendment Act was made invalid. That is, there was an invalidation. There was an invalidation of this 24th Amendment Act. Right? So 24th Amendment Act was invalidated. Right? So this is what said by Supreme Court in Keshavananda Bharati case. Right? So Parliament was given the power to amend any part of Constitution. Parliament was given the power to amend any part of Constitution, but without affecting basic structure of Constitution or basic features of Indian Constitution. Right? So without affecting this basic structure or basic features, right, Parliament has the power. Parliament has the power to amend any part of Constitution. It has power to amend any part of Indian Constitution. Alright. So this is what said by Supreme Court in Keshavananda Bharati case. That means any part of Constitution can be amended without violating the basic structure of Constitution. Then what about fundamental rights? Can they be amended or not? Can they be amended or not? You can add new things to fundamental rights, but you cannot remove the existing things from the fundamental rights. Alright? So that means what? Parliament has no power to remove or repeal the right which is mentioned in part 3. That means Parliament has no power to remove the rights mentioned in part 3. Article 31 cannot be removed. Article 31 cannot be repealed. So this was said by Supreme Court. Alright. So without affecting the base structure of fundamental rights, you can amend anything. You can add new things to fundamental rights. Alright. So this what? That means what? In the name of basic structure of Constitution, right? If you take the impact of this basic structure, in the name of basic structure of Constitution, Parliament's power were restricted. Yes or no? Parliament power is restricted. Do you accept or not? Yes, right? So there is a restriction on Parliament's power to amend the Constitution, right? So Parliament has no power. Parliament has no power to amend the Constitution, right? Parliament has no power to restrict what you call the basic. Parliament is restricted in its power to amend basic structure. In simple words, right? The basic structure cannot be violated. The basic features cannot be amended. So Parliament has no power to amend basic features. So this is a restriction. So on one hand, we see restrictions being imposed on the power of Parliament. On the other hand, in the name of in the name of basic structure, judiciary enjoyed more powers, right? So that means, right, basic structure, the doctrine of basic structure led to judicial supremacy. The doctrine of basic structure led to judicial supremacy. It led to judicial supremacy. Alright. So this is what we can see. This is the impact of doctrine of basic structure. This is the impact of doctrine of basic structure. So on one hand, the power of Parliament is restricted, right? On the other hand, what you call the it led to supremacy of judiciary. That means what? In the name of basic structure, now judiciary can review both the laws made by Parliament as well as acts of government. That means the doctrine of basic structure only strengthened the concept of judicial review, right? So judicial review got strengthened, right? The concept of judicial review got strengthened. Judicial review got strengthened. Alright, so this is what done. This is what done by Supreme Court. Right, we see strengthening of judicial review. Right, this is the outcomes, or this is the impact of basic structure. Right, so Keshavananda Bharati case is known for these things. Alright, so once again I will simply rewind. Right, in Keshavananda Bharati case, Supreme Court upheld the power of Parliament to amend any part of Constitution including fundamental rights without violating the basic structure. Right, so it has invalidated the judgment given in Golaknath case as well as 24th and 25th Amendment Acts. Right, the impact of this basic structure is it has strengthened judiciary and it has weakened Parliament. Right, so this is what the outcomes of what we call Keshavananda Bharati case. Now, do you think that the debate got ended here? Right, because as long as Indira Gandhi was in power, this debate went on. Right, we see a continuous debate on this. That means, right, even after this Keshavananda Bharati case judgment, right, Indira Gandhi government has come with 38th Amendment Act as well as 39th Amendment Act amending fundamental rights, right, saying that, right, by following Article 368, right, that is by following the procedure given in Article 368, the Parliament has made this 38th Amendment Act and 39th Amendment Act, but said that the laws made by Parliament are not questionable in judiciary. So that means though the procedure given in Article 368 is followed, by Parliament in amending the Constitution, all such laws made by Parliament cannot be questioned in Supreme Court. That means what Indira Gandhi government is saying, the government says that it will follow Article 368. It will follow the procedure given in Article 368 to amend the Constitution. But the thing is, the judiciary should not question the laws made. The same thing was done. That means what? Whether Indira Gandhi government is giving any respect to the judicial judgments? No respect is given. Right? So this judgment, that is the judgment on Keshavananda Bharati case came in 1973, and in 1975 again she made amendments. Right? Clearly violating this Keshavananda Bharati case, clearly violating the judgment given by Supreme Court. She want judiciary not to interfere with the power of Parliament and government. Simply, right, Indira Gandhi doesn't wanted the courts to be a hurdle. She never wanted courts to be a hurdle in the way of power of Parliament. Right? She never wanted, right, Supreme Court or courts, any other court. Right? So she never wanted courts to question the laws made by Parliament. Right? So that is what the intention. Of Indira Gandhi. So every time she made, right, whenever she made an amendment, she clearly said that court should not interfere. Supreme Court should not interfere. Right? That means Indira Gandhi government always wanted a smooth road for passing the laws. She never wanted any kind of hurdle, right, in the way of power of Parliament. Right? She wanted a smooth way for passing the laws, including amending the Constitution. Today we are talking about these issues. Today we see a debate. So if you take this, one of the electoral debates is, right, rewriting the constitutions. Right? Both ruling party and opposition parties, they are talking too much on this rewriting of constitution. Now, whether Parliament has the power to rewrite the constitution, Parliament has no power to rewrite the constitution. This is clearly said by Supreme Court in Keshavananda Bharati case. Alright. So in Keshavananda Bharati case, Supreme Court said that Parliament has the constituent powers. Parliament has constituent powers, but it took a different meaning. Though it said that Parliament has the constituent powers, but the meaning of constituent power is different. What is the actual meaning of what we call constituent powers? It means power to rewrite the constitution. Just now I have mentioned. Alright, constituent powers means it is the power to rewrite the constitution. Alright, so power to rewrite the constitution. But remember, Supreme Court in case of the Bharati case held that though Parliament has the power to, though Parliament has constituent powers, it doesn't mean that it can rewrite the constitution. Alright, so though Parliament has the constituent powers, it cannot rewrite the constitution. That is, it cannot change. It cannot change the basic structure of constitution. And remember, there is a big list of basic structure, right? So when we will discuss this, what you call amending powers of Parliament, then I'll list out all these basic structures. But as of now, remember that Supreme Court in various judgments, remember all these basic features or basic structures, they are not given in one single judgment. They are not given in one single judgment. They are given by Supreme Court in different judgments. Alright. So we have a list of basic structure. Right. So Parliament can amend any part of Constitution without violating this basic structure. That means what? You cannot alter Indian Constitution. Right. Right. No one. Right. Right. It is immatter who comes to power. It is immatter which party comes to power, but no party has the power to rewrite the constitution. No party has the power to amend the constitution. Everyone talks about amending the constitution, changing constitution, rewriting the constitution. Do you think that constitution is that what you call a toy in the hands of political parties? Right? Right? Whether political parties controls constitution or constitution controls political parties. It is constitution which controls everything in India. Right? We should remember this point. Alright, every political party should remember this point that it is the constitution that controls everything. Alright, so no one is above the constitution. No one is above the constitution. Alright, so no one has the power. No one has the power to amend the constitution. No one has the power to amend the constitution, right? So this is what said by Supreme Court in what you call Keshavananda Bharati case, right? But still, right? Indira Gandhi, as I was saying, she has come with what you call 38th Amendment Act as well as 39th Amendment Act, right? Just what you call going against the judgment given by Supreme Court, right? She said that is Indira Gandhi government said that the laws made by Parliament. The laws made by Parliament are not open for judicial review. They are not open for judicial review. That is, the courts cannot question the laws made by Parliament, including the constitutional amendment laws. Right? So, in Raj Narayan versus Indira Gandhi case, in Raj Narayan versus Indira Gandhi case, alright, it was Raj Narayan who has contested against Indira Gandhi, and it is Raj Narayan who claimed that Indira Gandhi has won the elections by faulty methods, right? So that is the reason why it was in this case Supreme Court held that free and fair election is a basic structure of constitution. It is only after this judgment, alright, the Indira Gandhi started imposing what you call emergency. Right? After Supreme Court invalidated the election of Indira Gandhi, she went for emergency. Alright. So in Raj Narayan versus Indira Gandhi case, Supreme Court clearly held that every law that is made by Parliament, right, every law that is made by Parliament, whether it is ordinary law or a constitutional amendment law, every law that is made by Parliament, whether ordinary or a constitutional, whether ordinary or a constitutional amendment law, whether ordinary law or a constitutional amendment law, they are subjected to judicial review. That is, they can be questioned. They can be questioned. That is, they are subjected to judicial review. These laws are subjected to judicial review, right? So this is what said by Supreme Court. This is what said by Supreme Court in Raj Narayan versus Indira Gandhi case. Yes, he has opposed what you call Indira Gandhi's election. He has challenged. So first it was challenged in Allahabad High Court, then the judgment of Allahabad High Court was reviewed in Supreme Court. Alright. So that means what? Alright. Again, so even after this Raj Narayan case, Indira Gandhi government came with what you call 42nd Amendment Act. Right. Indira Gandhi has amended Constitution in 1976. Alright. In 1976, Indira Gandhi has amended Constitution, alright, which for the 42nd time, that is, it is popularly called as 42nd Amendment Act, where by this 42nd Amendment Act, each and every part of Constitution was amended, including preamble, including fundamental rights, everything was amended. So again, there was a tilt of balance in favor of Parliament. So there was always a question. So there was, if you take this what you call amendments made by Indira Gandhi and judgments of Supreme Court. If you take this what you call conflict between judiciary and executive, simply this is a conflict. We can see it as a conflict between the Indira Gandhi government, the Indira Gandhi and judiciary. Right? Indira Gandhi comes with an amendment, and these amendments are invalid by Supreme Court. When Supreme Court makes a judgment, passes judgment, again against the judgment, Indira Gandhi government comes with a what you call amendment. So there is a what you call a kind of a Tom and Jerry, right, between Indira Gandhi and judiciary. All right. So we are seeing this 24th Amendment Act, Keshanda Bharti case, 30th Amendment Act, Raj Narayan case, 42nd Amendment Act, again Minerva Mills case. All right. So there was what you call a change in balance between judiciary and executive. All right. So even after Raj Narayan case, Indira Gandhi government has passed what you call this 42nd Amendment Act, which is called as Mini Constitution of India. Right. 42nd Amendment Act is called as Mini Constitution of India. All right. So if you take this Mini Constitution of India, all right, every part of Constitution was amended, including fundamental rights. All right. In the name of what you call welfare state, because Indira Gandhi gave the slogan of Garibi Hatavo. If you take the elections, the 1975 elections, all right, so she has gave the slogan of Garibi Hatavo. All right, and even when there was no support from her own political party, remember, Indira Gandhi was not supported by her own Congress party. That is the reason why we see a split in Congress party, Indira Congress and what you call in Congress O, Congress I and Congress O. They were split in 1970s, right? Because of the attitude of Indira Gandhi. It is simply because of attitude of Indira Gandhi, right? So we had seen this kind of split. We are seeing this kind of split, right? So because of this, all right, because of this 42nd Amendment Act, right, many changes are brought, and all these changes brought by 42nd Amendment Act, they were corrected by 44th Amendment Act, right? So 44th Amendment Act has corrected, right, These changes brought by 42nd Amendment Act. So one of the most important impact of 44th Amendment Act on fundamental rights is, alright, deletion of this 31, Article 31, that is right to property. Alright, so right to property was removed from the list of fundamental rights. The right to property was removed from the list of fundamental rights. So this is the most important impact of 44th Amendment Act. Alright, and the debate on this issue of amending part 3, amending part 4, right, power of parliament to amend the constitution, power of parliament to amend any part of constitution. So ultimately the end to this debate came in Minerva Mills versus Union of India case. Minerva Mills versus Union of India case. Right? Minerva Mills versus Union of India case. So in this case, Supreme Court held that, alright, primacy is given to fundamental rights. Alright, that means these fundamental rights cannot be violated. Right? But along with fundamental rights, though part 4 of constitution, we take this part 4 of constitution deals with what? Directive principles of state policy, right, which aim at establishing welfare state, right. So these DPSP are directive principles of state policy which are mentioned in part 4. They aim at welfare state, creating welfare state, right. So Supreme Court in Minerva Mills case held that primacy is given to fundamental rights, but along with fundamental rights, DPSP are also important. So it said that, Supreme Court said that our constitutional framers, the framers of Indian Constitution, clearly established a balance between, the framers of Indian Constitution have clearly established a balance between part 3 of Constitution as well as part 4 of Indian Constitution. Alright. So this balance is the balance between fundamental rights and DPSP. They are, right, a basic structure of Constitution. Supreme Court held that the balance between part 3 and part 4 of the Constitution, is a basic structure of Constitution. It is a basic structure of Constitution. Alright. So this is what? Alright. And it clearly held that, right, in this case, another important highlight of this case is, in this case, that is in Minerva Mills versus Union of India case, Supreme Court clearly held that Parliament has every power to amend Constitution. It has power to amend any part of Constitution including fundamental rights. The only thing is without violating the philosophy of basic structure, right? So without violating the philosophy of basic structure, the Parliament has every power, right? Without violating the philosophy of basic structure, the Parliament has every power to amend the Constitution. Alright. So, the same thing, because in between these two, what happened? There was a kind of changes made. So that means what? Supreme Court once again reiterated the previous thing, right? So here the another difference is, Supreme Court held that Parliament can amend even the basic structure, but without violating the philosophy of basic structure. Alright. So it is absolute rule of basic structure that was used in Kakatiya Bharati case, but here it is the philosophy of basic structure. Simply to say, I'll say one thing. Right, in Kakatiya Bharati case, Supreme Court said that Parliament has no power to amend preamble. But you can amend preamble without violating the philosophy of preamble, right? Without undermining the importance of preamble, right? So this is what said by Supreme Court in Minerva Mills versus Union of India case, right? So this is the debate on amendments to fundamental rights. That is Minerva Mills versus Union of India case marks what you call an end to this debate on amendments to fundamental rights. At the end, we can say that fundamental rights can be amended. So Parliament has every power. Parliament has every power to amend fundamental rights. Parliament has every power to amend the fundamental rights. Okay. So this is the end of the debate. Once again, so I think you have seen so many of cases. So if you take this issue, because when we write answer in UPSC, at least we should what you call use 3 to 4 cases. Alright. So there should be 2 landmark cases that should be used to write the answer, because without these Supreme Court judgments, without these Supreme Court judgments, you cannot justify answers. You cannot justify the answers in UPSC. So remember, coming to polity, the answer standardization comes only through Supreme Court judgments. Supreme Court judgments, amendments made, right? So whenever you are writing answers in polity, alright, you need to use these judgments. At least write 2 to 3 case studies. Alright. So first let you take a question on this, then I'll explain. Once again I'll revise everything. Take down a question on this point. Discuss the issue of amendments to fundamental rights. Discuss the issue of amendments to fundamental rights. Discuss the issue of amendments of fundamental rights by using Supreme Court judgments. So use 2 important judgments. One is Golaknath and second one is Keshavananda Bharati. And at the end conclude by using Minerva Mills case. Alright. So before Golaknath, alright, if you want you can write this Shankar Prasad case or Champakam Dorrajan case or Sajjan Singh case. Then after Golaknath, then you can see use these 3 case laws. Alright, use these 3 case laws and write the answers, right? So just use these landmark judgments and give the answers. So though we have discussed, say for example, we have discussed Shankar Prasad case, Champakam Dorrajan versus State of Madras case. Then we have talked about Sajjan Singh versus State of Madras, Sajjan Singh versus State of Rajasthan case. In all these cases, Supreme Court held that Parliament has the power to amend fundamental rights, right? And all such laws made by Parliament need not be questioned in Supreme Court because they are given immunity by using 9th schedule. But in Golaknath case, Supreme Court said that Parliament has no power to amend the fundamental rights. Parliament has no power to amend the fundamental rights, and fundamental rights are given sacrosanct portion. And Supreme Court said that Article 368 only talked about procedure, but it has not conferred any power on Parliament. So if at all amendments are to be made, it should be done by a new constituent assembly, but not by Parliament, right? So this is what said by Supreme Court in Golaknath case. But in, after this, the government of India has brought 24th Amendment Act and 25th Amendment Act, amending Article 13 as well as Article 368. Alright. So simply imposing a restriction on Supreme Court. That is, the laws made by Parliament are not allowed for questioning in Supreme Court. And by this 24th Amendment Act, right, President was bound to give his assent on constitutional amendment laws. We have seen Article 13 as well as Article 368 being amended. Right. So all these issues, that is the judgment given in Golaknath case, the 24th Amendment Act, the 25th Amendment Act, they were challenged in Supreme Court. They came for discussion in Supreme Court in Keshavananda Bharati case, in Keshavananda Bharati versus State of Kerala case, where Supreme Court held that Parliament is the sole institution to amend the Constitution, and so that Parliament has every power to amend any part of Constitution without violating the basic structure of Constitution. Right. Similarly, Supreme Court said that Article 13, Article 368 are basic structures of Constitution. Right. So this is what said by Supreme Court in Keshavananda Bharati case. But still after that, there were changes made by government in the form of 38th Amendment Act as well as 39th Amendment Act, which were challenged in Supreme Court in the form of Rajnaran versus Indira Gandhi case. Again, in this Rajnaran case, Supreme Court held that every law that is made by Parliament, either an ordinary law or a constitutional amendment law, they are open for judicial review. That is, they can be questioned in Supreme Court. Then after, the Government of India has come with 42nd Amendment Act, which is called as mini constitution, by which every part of constitution was amended, including part 3, the preamble and every part. So the changes made by 42nd Amendment Act, they were again they were again changed by 44th Amendment Act, right, where the highlight of this 44th Amendment Act is removal of Article 31, that is right to property, from the list of fundamental rights. Right. And it was made a constitutional right but not a fundamental right. That is, it is a right outside of part 3, which is mentioned in Article 300. So this right to property was inserted in Article 300. Right. So this is one thing. Alright. Now, at the end, in Mineral Mills versus Union of India case, the Supreme Court held that fundamental rights and DPSP are what we call soul of Constitution. The balance between these two is a soul of Constitution. They are regarded as two wheels of chariot of Indian Constitution, and primacy is given to fundamental rights over DPSP, and said that Parliament has every power to amend Constitution, including base structure, without undermining the philosophy of basic structure. That means, though Parliament has the power to amend anything, including base structure, it cannot undermine the philosophy or importance of basic structure of Constitution. Am I clear to you? Right? So this is what said by Supreme Court in Mineral Mill case. So this is what about the rewind of what we have discussed till now. Rewind of what we have discussed till now. Right? I think I am clear about these two debates. One is restrictions on fundamental rights as well as the issue of amendability of fundamental rights. Now let us discuss, right, these fundamental rights which are mentioned in the Constitution. Alright. So first of all, let me give a clarity about Article 12, which deals with the definition of state. Right. State means right, any state means simply a group of people. State means a group of people who are politically organized. Living in a particular geographical territory. State means what? It is not simply a territory, it is not just a geographical territory. It means, right, a geographical territory where group of people who are politically organized living together. It is called as state. Right? That means it can be any political unit. Simply, state can be State can be any political unit. It can be any political unit, right? It includes executive and any organ of executive. It includes executive or any organ of executive. Say for example, ministries, departments, public sector corporations, agencies, all right, Niti Aayog, anything, all right, all they are executive organs. It includes legislature, that is parliament, assembly, right, Raj Sabha, Lok Sabha, right, legislative council, and all those institutions which are created by law. That is, it also includes statutory bodies. It includes statutory bodies, right? Statutory bodies means all right, all those institutions or agencies which are created by law, all those institutions which are created by law, they are called as statutory bodies. Best example, SEBI, NHRC, CVC. So all these are examples of statutory bodies. All right. So these are executive bodies, legislative bodies, quasi-executive and quasi-legislative. State, the definition of state also includes quasi-executive and quasi-legislative. Quasi means what? Partly, right? Partly executive and partly legislative. So state includes, the meaning of state includes partly executive and partly legislative bodies. All right. So these are different institutions. Which are a part of. These are different institutions which are a part of executive and legislative institutions. Right. So, but here judicial bodies, that is Supreme Court, is not included in the definition of state. Right. Because the reason for it is the Supreme Court. It is the Supreme Court which interprets. Constitution. Right. So when Supreme Court is given adequate independence, it is only then it can act as a watchdog or guardian of Constitution. All right. So another important point is the definition of state also includes the local bodies. The definition of state also includes local bodies. It also includes local bodies. All right. So this is what. So that means whenever I use the word state, that state includes any of these institutions. Am I clear? So be clear of this word state. So in the entire discussion on polity, we always come across this word of state. So state means any of these institutions. All right. So what I'll do is I'll take a break here, and after the break I'll discuss each of the articles individually. That is from articles 14 to articles 35 of Indian Constitution. All right. So let me take a break of 5 to 10 minutes. Don't run away. So now let me talk about different before going to different fundamental rights, let me once again just give me a hint about article 13. So if you take this article 13, article 13 talks about consistency of laws. It talks about consistency of laws. That means what? Every law that is made by state, should be consistent with constitution, right? Every law that is made by state should be consistent with the constitution. And all those laws which are inconsistent with the constitution, the laws which are inconsistent, with constitution, they are simply made nullified and void. All those laws which are inconsistent with the constitution, they are nullified and made void. So that means every law, including pre-constitutional laws, they should be consistent with the constitution, right? If they are not consistent with the constitution, they are simply nullified and made void by using doctrine of severability. So one is doctrine of severability, another one is doctrine of eclipse. One is doctrine of severability and the other one is doctrine of eclipse, right? So both these doctrines, both doctrine of severability, severability, right? Doctrine of severability and doctrine of eclipse are used, right? Both these doctrines are used to nullify and make void those laws which are not consistent with the constitution. Because remember, if you take the history of Indian constitution or Indian laws, most of the pre-constitutional laws, that is those laws which are made by British India government, they are also used, even after independence, that is even after commencing the constitution, even after commencement of constitution, we have adopted these laws. The best example is CRPC, CPC, IPC. So all these are pre-constitutional laws made in 1861, 1860, 1859. We have Indian Evidence Act of 1872. Alright, so we have many such laws. Alright, which are in usage even today. Alright, and those pre-constitutional laws which are not consistent with the Indian constitution, those pre-constitutional laws which are not consistent with Indian constitution, they are made nullified. That means simply they are invalidated. So nullified and void means it is invalidation. They are invalidated. So these laws are invalidated. That means they will not be enforced, that is they will not be effected. So this is what Article 13 says. Alright. Now it is judiciary that will check. Judiciary being the guardian of constitution, judiciary being the guardian of fundamental rights, it has every power to examine, it has every power to examine the laws made by parliament, examine the laws made by parliament. It has every power to examine the laws made by parliament, right? So, this is what the element is. And this was upheld Supreme Court in A.K. Gopalan case. Just now in the previous session we have talked about this. In A.K. Gopalan case, Supreme Court clearly said that judiciary has the power to review the acts of executive, right? So, judiciary has every power, judiciary has every power to examine, right, what you call the laws made by parliament and check whether they are consistent or not. That means what? Judiciary will check the consistency of laws, judiciary will check the consistency of laws made by parliament, alright. So, this is what about Article 13 is, alright. So, you should remember both Article 12 as well as Article 13. Article 12 defines the state, whereas Article 13 deals with consistency of laws made by parliament, right? I think you are clear about this, both Article 12 as well as Article 13 of the Constitution. Next, moving on to individual fundamental rights, right? So, let me talk about different rights mentioned in Indian Constitution. So, if we take these fundamental rights mentioned in part 3, we can classify them as 6 categories. One is right to equality. One is right to equality, which are meant from Article 14 to Article 18, right? Right to freedoms. Right to freedoms, which are mentioned from Articles 19 to Articles 22. Then rights against exploitation. Rights against exploitation, which are mentioned in Article 23 and Article 24. Then right to religious freedoms. Right to religious freedoms, which are mentioned in Article 25 to Articles 28. Next, educational and cultural rights. Educational and cultural rights 29 and 30. Then right to constitutional remedies. Right to constitutional remedies, which are mentioned in Article 32. Right. So, it is this Article 32 which is regarded as bulwark of Indian Constitution. Bulwark of Indian. No? It is removed from the list of fundamental rights and added to Article 300A, right? So, we are seeing Article 31 being missed. Remember, after 44th Amendment Act, right to property, was deleted from the list of fundamental rights. It is removed from the list of fundamental rights. That means now we don't have this right to property. Alright. So, whereas Article 32 is regarded as bulwark of Indian Constitution. Right. It is regarded as bulwark of Indian Constitution. Okay. Let me now talk about each of these rights. Right? Let me start with right to equality, that is Articles 14 to Articles 18. All right. Article 14 states that all are equal before law. All right. All are equal before law. That is, there are two elements, and there is an equal protection of laws. Equal protection of laws. All are equal before law, and second one is equal protection of laws. So let me first talk about equality before law. Let me first talk about equality before law. Alright. So this is the first element, which is taken from British Constitution. This element is taken from British Constitution. It is taken from British Constitution. Now it says that all are equal. That means no one is above the law. Right? So it means that no one is above the law. So all means everyone, including the lawmakers, they are equally subjected to law. They are equal in front of law. Right? So before a law, no one is above. All are equal. Right? So all means both common citizens as well as the lawmakers. Who makes the law? It is MPs and MLAs. Right? Even MPs and MLAs in India are equal before a law. Right? There is one point to remember here. Right? If you take Article 104 as well as Article 193 of Indian Constitution. Article 104 and Article 190 of Indian Constitution provides privileges. It provides privileges to MPs and MLAs. All right. (104), 105, Article 190, 191. It provides privileges to both MPs and MLAs. Remember, these privileges are used. These privileges should be used only within the four walls of the house. Remember, these privileges are within the house. Within the house, but not outside the house. These privileges cannot be used beyond the house. That means, though they have privileges, it is only within the house during the law-making process. So these privileges are used by MPs and MLAs during the law-making process, and they are not applicable outside the house. Outside the house, they are equal in front of the law. So no one is above the law. No one enjoys any privilege, right? According to Article 14. So whenever we talk about privileges, whenever we talk about equality, equality clearly promotes that. Equality clearly says that there are no privileges. So equality means non-existence of any privilege. Equality means non-existence of any privileges. Non-existence of any privilege. That means no one enjoys any privilege. So what do you mean by privilege here? What do you mean by? So it is special treatment. That means what? No one is given any special treatment. No one enjoys any special treatment. No one enjoys any special treatment. So all are equal. All are equal in front of the law. No one enjoys any special treatment. Right? So there cannot be any discriminatory treatment. That is what equality is. Alright? So here, when we talk about this equality, equality clearly promotes absence of privileges, absence of special treatment. So though there is absence of privilege and absence of special treatment, but there is an exemption. The exemption is given to President of India as well as Governor of the state, right? Both President of India as well as Governor of the state, they are being given exemptions. That means no civil proceeding can be initiated against President or Governor for all those acts done by them. No civil proceeding can be initiated against President or Governor for all the acts done by them during their term of office. అంటే వాళ్ళు తన పదవీ కాలంలో ఉన్నంత వరకు వాళ్ళు చేసిన ప్రతి అఫీషియల్ వర్క్కి ఎలాంటి సివిల్ ప్రొసీడింగ్ని ఇనిషియేట్ చేయడానికి వీలు లేదు. రైట్? సో నో సివిల్ ప్రొసీడింగ్ కెన్ బి ఇనిషియేటెడ్ అగెయిన్స్ట్ either president or governor, right, for all their works done in their official capacity. Similarly, no criminal proceeding can be initiated during the term of office for all their acts done without providing a 14-day notice. That means a 14-day notice is essential for president and governor for initiating criminal proceedings. So this is the exemption. So this is the privilege that they enjoy. They enjoy this privileges against civil proceedings as well as criminal proceedings. And coming to criminal proceedings, the privilege is given only for 14 days. That is, without providing 14-day notice. Without providing a 14-day notice, no privilege, no a criminal proceeding can be initiated against the president or governor. Right? So these are the exemptions given to president and governor. And coming to the others, that is, you take the MPs, MLAs, the members of executive, the public servants, everyone, all are equal. All are equal before law. All are equal before law, and no one is above the law. No one is above the law. Right? So this is what our constitution states. Right? This is what the first element of Article 14, that is equality before law. And coming to second element, that is equal protection of laws. Coming to second element, that is equal protection of laws. Alright, in a single word, right, I can say that, right, it means similar treatment. Article 14 provides similar treatment. Equal means it is same. Alright? Whether same and similar are same, whether the words same and similar, do they connote the same meaning? రెండింటికి అర్థం ఒకటేనా? సేమ్ సిమిలర్కి అర్థం ఒకటేనా? దేర్ ఈజ్ అ డిఫరెన్స్. అంతే కదా, తేడా ఉందా లేదా? దేర్ ఈజ్ అ డిఫరెన్స్ బిట్వీన్ సేమ్ అండ్ సిమిలర్. రైట్? సో దట్ మీన్స్ in Indian constitution, on one hand we talk about equality, at the same time we also talk about similar treatment. That means there is a what you call differentiation. Right? I'll explain this. So Article 14 has both these elements. Remember, this concept of equal protection of laws, this concept of equal protection of laws is taken from, it is taken from American constitution. The first one is taken from British constitution, and second one is taken from, it is taken from American constitution. The second concept is taken from American constitution. Alright? So if you take the second one, it states that all those individuals who are placed under similar conditions should be treated similarly. All those individuals who are placed, all those individuals who are placed under similar conditions. All those individuals who are placed under similar conditions should be treated similarly. Should be treated similarly. That means the one who are placed in equal situations, that means the one who are placed under equal situations, they should be treated equally. The one who are placed under equal situations, they should be treated equally. These individuals should be treated equally. Then what about the individuals who are placed in different situations? The one who are placed in equal situations should be treated equally. Then what about individuals who are placed in different situations? What about them? Should they be treated equally or should they be treated differently? When you are placed in equal situations, you should be treated equally. When the individuals are placed in different situations, they should be treated differently. Right? So equals in equal conditions, differently in different conditions. That is what the meaning of this, what you call Article 14. Right? Alright? So here, when you are in the same situations, the people who are in the same situations should be treated similarly. That is, they should be treated equally. That is, same treatment should be given to the individuals. Same treatment should be given to the individuals who are placed in same situations. Alright? I'll take one simple example to make you understand. Alright? The regions which are declared as disturbed conditions. The regions which are declared as disturbed conditions. So in the yesterday's elections, we have seen some of the areas in Andhra, right, where there was much kind of violence, which are declared as disturbed conditions, and there is a different laws placed, right? And there are states in India, right, which are placed under different conditions, right, which are declared as disturbed areas, right? The case of Manipur, the case of Nagaland, the case of Jammu Kashmir, the certain areas in these states, not the entire states, but there are certain areas in these states which are declared as disturbed areas, right? Now people living in the disturbed areas and the people living in normal areas, that is those areas where there is no disturbance, should they be treated equally or should they be treated differently? Alright, the people who are living in undisturbed areas and the people who are living in disturbed areas, should they be treated similarly or differently? And other way, whether it is same law that is applied both in undisturbed areas and disturbed areas. So where are the areas which are declared as disturbed areas, they are, right, we see implementation of section 144, curfew, right? So curfews are simply imposed on disturbed areas. In normal areas, right, do they have any curfew? There is no curfew in normal areas. That means what? The people in normal areas, they enjoy every right, and the people who are in curfew areas, will they enjoy all the rights? No. Right? That means the people who are living in disturbed areas and undisturbed areas, will they be treated equally? No, they are not treated equally because there are different laws in application. రెండు చోట్లలో వేరు వేరు లాస్ ఉన్నాయి. ఎక్కడ డిస్టర్బ్ ఏరియాస్ ఉన్నాయో అక్కడ 144 సెక్షన్ అక్కడ కర్ఫ్యూ ఉంది. అన్డిస్టర్బ్ ఏరియాస్లో కర్ఫ్యూ లేదు. There is no section 144. There is no 144 section. Alright? So, this is what you call the difference. And the one who are placed in similar situations will be treated similarly. The one who are placed in different situations will be treated differently. Then the one who are in equal situations, they will be treated equally, and the one who are in different situations, they will be treated unequally. That means don't blindly believe that. Don't blindly believe that Article 14 only promotes equality. In Article 14, we have both equality as well as inequality. So, equality is seen in equal situations, right? Unequal treatment is seen in unequal situations, right? The one who are placed under different situations, the one who are placed under different situations, the one who are placed under different situations, they are treated unequally. So, when we talk about equality, we should also talk about the situations, the prevailing conditions or the prevailing situations. అంటే వాళ్ళు ఏ కండిషన్స్లో ఉన్నారు, ఏ సిచ్యువేషన్లో ఉన్నారు, అది కూడా ఇంపార్టెంటే. The one who are placed in equal situations, they can claim equality of treatment. But the one who are in different situations, they cannot claim equality. The one who are placed in different situations, they cannot enjoy and they cannot claim equality of treatment. That is what Article 14 says. Here in this Article 14, do you think that it is individuals who are differentiated or the conditions which are differentiated? So, what is differentiated in Article 14? Whether it is individuals or conditions? It is conditions. Remember, it is conditions. So, Article 14 allows classification of situations. Classification of conditions or situations. Article 14 allows, right, classification of situations or conditions in which the individual is living. All right. So, be very clear. The individuals are never classified under Indian Constitution, right? So, there is no classification of individuals. There is a stricter forbidding of, right? Our Constitution forbids classification of individuals. Our system, our Constitution forbids classification of individuals. But what is allowed is classification of conditions, and equality is always read, right? ఎప్పుడైతే మనం ఈక్వాలిటీ అంటామో ఖచ్చితంగా అక్కడున్న కండిషన్స్ కూడా మనం దృష్టిలోకి పెట్టుకోవాలి. సో కండిషన్స్ని సిచ్యువేషన్స్ దృష్టిలో పెట్టుకోకుండా ఈక్వాలిటీ అన్నదాన్ని చూడడానికి వీల్లేదు. ఈక్వాలిటీ అన్నది అక్కడున్న కండిషన్స్, అక్కడున్న సిచ్యువేషన్స్ పట్ల, అక్కడున్న కండిషన్స్ లేదా సిచ్యువేషన్స్ మీదనే డిపెండ్ అయి ఉంటుంది, రైట్? The concept of equality depends upon the prevailing conditions and situations. Alright, so this is the second element. Alright, Supreme Court clearly upheld this equal protection of laws. Supreme Court clearly upheld the equal protection of laws in St. Stephen's College case. St. Stephen's College case, very popular case. It was in this case, right, where Supreme Court for the first time has upheld classification of conditions to the right to read equality, right? So Supreme Court said that, right, to understand equality, the conditions in which the individual is placed should also be read. It is not just the physical conditions, the socio-economic conditions of the individuals should also be read, should also be taken into considerations, right? It is the socio-economic conditions. It is the socio-economic conditions of the individual. It is the socio-economic conditions of individuals should be read to read equality. Alright, so during giving admissions in this St. Stephen's College case, alright, there was a differential treatment of individuals, right? So there is a differential treatment given to individuals in giving the admissions, and the Supreme Court justified this differential treatment, right, to the students in getting admissions based upon the conditions prevailing. Supreme Court said that equality cannot claimed, right, as a right. So when equality is claimed, the socio-economic condition should also be read along with the equality, right. That means all the people who are placed under all the individuals who are placed under same socio-economic conditions, they can enjoy equality, and the one who are placed under different conditions, they cannot claim equality. That means there can be unequal treatment. There can be unequal treatment of individuals. There can be unequal treatment of individuals who are placed under unequal conditions, unequal socio-economic conditions. So the claims of reservations, it starts from this point. The claims of reservations starts from this, what we call Article 14. That is second part of Article 14. That is equal protection of laws. Every law that is made by the government has same kind of protection. Every law that is made by the state, it has same kind of validity. You cannot give one importance to one law over the other law. All the laws are equally important. So government ఏ law చేసినా ప్రతి law important, and laws are made based upon the existing conditions, and laws are applied based upon the existing conditions, right. So every law that is made by the state, it is equally important. Every law has an equal importance and equal protection under the Constitution. So no law will be given importance over the other laws. So this is what Article 14 states, right. So once again I repeat, Article 14 talks about equality before law and equal protection of laws. Equality is nothing but, right, non-existence of any privilege, non-existence of any discrimination, right. So non-existence of any special treatment. Whereas coming to the second one, that is, if you take this, what you call second element, the element of equal protection of laws, it says that all those individuals who are placed under equal conditions will be treated equally, and the one who are placed under different conditions will be treated differently, right. So equals should be treated equally, unequals should be treated unequally. That is Article 14 second clause, it promotes unequal treatment in unequal conditions. So it is not the individuals, but it is the conditions which are being classified. So classification is based upon the classification of situations. Classification is based upon classification of situations. Alright. So this is what Article 14 is. I think you are clear about Article 14. Am I clear? Adhamayinda? Yes, it is all the forms of equality. See here, when we are talking about Article 14, it promotes all the forms of equality. But when you are talking about all the forms of equality, you should also take these conditions of the individual in which they are living in promoting the equality. That means whether all the people are in the same conditions in India? No. That means when there is no equal conditions, obviously it means what? There can be differential treatment of individuals. There can be importance given to certain individuals. We will talk about this in Article 15. Right? As all the individuals are not placed under same conditions, అందరూ ఒకే కండిషన్స్లో లేరు కాబట్టి, అందరూ ఒకేలాంటి సోషో ఎకనామిక్ కండిషన్స్లో లేరు కాబట్టి, సోషో ఎకనామిక్ అండ్ పొలిటికల్ కండిషన్స్లో లేరు కాబట్టి, దేర్ కెన్ బి డిఫరెన్షియల్ ట్రీట్మెంట్. That means based upon their socio-economic conditions, they are being given reservations. Right? So coming to Article 15 of Constitution. If you take this Article 15 of Constitution, Article 15 prohibits discrimination. Article 15 prohibits discrimination only on the grounds of, right? Prohibition of discrimination. It prohibits discrimination. Article 15 prohibits discrimination on the grounds of caste, creed, gender, place, right, region, religion, right. So on these grounds, that is, we have caste, creed, gender, place of birth, region, religion, right. So on these grounds there shall not be any discrimination, but right, and all are treated equally. This is what originally Article 15 says, but by the subsequent amendments made to Constitution, special treatment are given. Special treatment is given to women and children. Article 15, Clause 3. Article 15, Clause 3. Special treatment, that is, state is allowed to make special laws, right, to provide special treatment to women and children. Women and children. 15 Clause 4 provides, it has allowed, right, 15 Clause 4. So these 3 and 4, they were added to Article 15 by amending Article 15, right. So special provisions, state is allowed to make special provisions, right, for the upliftment of socio-economically weaker sections of society, all right. Special provisions, state is empowered to make special provisions for the upliftment of right, social and economically weaker sections. For the upliftment of social and economically weaker sections of society. Alright. So that is what Article 15, Clause 4 says. That means, who are socially and economically weaker sections of society? On what basis? The social and economically weaker sections of society are identified. If you take Indian society, on what basis these weaker sections of Indian society are identified? What is the normal criteria that is being used to identify these weaker sections of society? So initially it is caste. It is initially the caste. Caste is taken as the criteria, right? So it is only after 1992, income is being taken as a criteria, right? It is only after Supreme Court judgment in Indira Shane case, right? It is only after Supreme Court judgment in Indira Shane case, right? Income is being taken as a criteria, but initially caste was taken as a criteria. Caste is chosen as a criteria for what you call determining the weakness, right, to identify the weaker sections of society, right, socio-economic weaker sections, socially and economically weaker sections of society. They are identified based upon the caste. The one who are placed in the lower caste, they are treated as social and economically weaker, and the state is allowed, the government is allowed to make special provisions for upliftment of these weaker sections, right. That is scheduled caste and scheduled tribes, right. It is scheduled caste and scheduled tribes who are historically, right, they are socially and economically weaker sections. So government was allowed, the state was allowed, empowered to make special provisions. State is empowered to make special provisions for the upliftment of social and economically weaker sections of society, right. This is what added by what you call the first initial amendments, First Amendment Act, Second Amendment Act, right. It is by these amendments special provisions were made for these people, right. Later in 2005 by 93rd Amendment Act, in 2005 by 93rd Amendment Act, right, by 93rd Amendment Act, Clause 5 was added to Article 15, which provides the state to make, right, which empower the state to make special provisions for providing reservations, special provisions for providing reservations for OBCs in higher educational institutions, right. So state is allowed for providing reservations for OBCs, all right, OBCs in higher educational institutions like IITs, IIMs. So in higher educational institutions, the OBCs are given reservations. A 27% of quota is reserved for OBCs in higher educational institutions, right? And this was upheld by Supreme Court in Ashok Kumar Thakur, right? Ashok Kumar Thakur case, Ashok Kumar Thakur versus State of Maharashtra case. So it was in this case, it was in Ashok Kumar case, Supreme Court upheld the 27% quota for OBCs in higher educational institutions, alright. So reservations, so from 2005 onwards, reservations are given for OBCs, in higher educational institutions. And the landmark amendment, the 103rd Amendment Act, Amendment Act 2019 provided reservations for EWS, that is economically weaker sections of society, right, at 10% reservations. 10% reservations for economically weaker sections of society, that is all the people, the one who are not in the list of reservations, that is those caste groups who are not being given reservations, right, they are being given 10% reservations under this EWS quota in both employment as well as in what you call admissions, right. So this was added to Article 15, Class 6. Class 6 of Article 15. It provides for 10% reservations for EWS. 27%. Alright. So this is what about Article 15. So Article 15 prohibits discrimination only on the grounds, but only on the grounds of caste, creed, place, or gender, region, religion, but the grounds of weakers. So we don't have the ground of weakerness in Article 15. Article 15 lo weakness on the ground mention cheyaledu kabatti entadi by using this socio-economic backwardness, socio-economic weakness can be used to provide reservations, right. So special provisions are made for the upliftment of weaker sections of society in the name of socio-economic weakness as well as socio-economic backwardness, right. So this is what done, right, by way of Article 15 Class 4, Class 5 as well as Class 6 of the Constitution, right. Right. So this is about Article 15. So for now I'll stop the class on Article 15, but I want to say few things. Alright, few things about the videos that I am posting. Remember, I am posting videos on the terms and concepts. So here most of the people, the one who are listening on online, they feel that, alright, it is only a part of the video that is being posted, but be clear, it is not a part of the video. My intention is to make a video of 10 to 12 minutes, not more than 12 minutes video, because the attention span of every student is normally 10 to 15 minutes, right. So by taking this into consideration, the videos that I am posting, will be a duration of 10 to 15 minutes and not more than that. Second thing, alright, already we are having a 2.5 hour polity class, right. You can revise, you can watch the same polity class again and again, you can revise it, you can make a notes out of it, Alright, and most of the students are commenting that they want the previous videos. Every video is present in the channel, right? The only thing is that you need to subscribe it and you can check all the channels. So already there is a full class of polity, and again I don't want you to burden with economy. That is the reason why, right, in a day I am explaining 2 to 3 terms so that you will be more comfortable in understanding. The purpose is not to overburden you. So if you can understand these 3 terms a day, right, by the time, right, within what you call short period, we will complete this polity, we will complete, and you will come to know about the terms of economy. Alright, the total length of the video is 10 to 15 minutes and not beyond that. Don't think that it is a part of the video. This is one thing which I want to say. Second thing is, right, the thing which I was afraid of, in దేనికైతే భయపడినో అదే జరుగుతుంది. The one who are listening to online classes, they are very they are showing not that much interest in writing the exams. Right from day one, I am against this online, because in online mode, most of the students will take this class as a time pass and they will don't write the exam. I have seen only one student have written the exam. This only shows your seriousness. I want every aspirant who is preparing for UPSC to be serious. Rank వచ్చిందా రాదన సెకండరీ, మన ఎఫర్ట్స్ ఎలా ఉన్నాయి, మనం ఎలా కష్టపడుతున్నాం, మనం ఎంతవరకు కమిట్ అయినాం ఎగ్జామ్కి, అది చాలా ఇంపార్టెంట్. కమిట్మెంట్ టు ఎగ్జామ్ ఈజ్ వెరీ వెరీ ఇంపార్టెంట్. యూ నీడ్ టు రైట్ ద డిస్క్రిప్టివ్ క్వశ్చన్స్, ఆబ్జెక్టివ్ క్వశ్చన్స్. ఇలా చేయనంత వరకు ఏదో మన ఊహనే. ఇట్ ఈస్ ఓన్లీ ఫర్ టైం పాస్ యూ ఆర్ ప్రిపేరింగ్, ఆఫ్ కోర్స్. Right, my focus will be on the students who are in offline, ఎందుకంటే they are coming to class, they are writing the exams. I am very good with them, I am happy with them. Alright, so if you are really serious, do try write the exams. Alright, so it is, once again I am saying, these exams will help you a lot in the future. Alright, so without practice you cannot expect anything in the any success in UPSC. Success in UPSC depends upon what you call your practice, both objective as well as descriptive. Sincere practice is very very essential. Sincerity lekapothe, commitment lekapothe civils raadu. Right, this is one thing. And even I'll post the terms and concepts of what you call public administration, and I'll post a video on the descriptive questions that I've given in the previous exam. Already the key is sent to you and the explanation will also be uploaded, right, by 4 o'clock. Right, explanation on all the questions given on Saturday exam. So do be serious for the exam. Right, so I think you have understood my intention. So with this, I will stop the class here for today, and we'll meet at tomorrow the same time of 9:30. All right. Thank you.